Good afternoon to everyone at today's public hearing of the Vetting Commission established under Law Number 65 on the external evaluation of judges and candidates for judges of the Supreme Court of Justice. I'm Scott Bales, the chair of the commission, and I declare this session open. Hearing is being conducted under the commission's rules of organization and functioning as part of the evaluation process. The subject of today's hearing is Anatolie Turcan, a judge on the Supreme Court of Justice. The evaluation in relation to Judge Turcan was carried out under Law Number 65 on the external evaluation of judges and candidates for judges of the Supreme Court of Justice. Judge Turcan, welcome. I'm joined by 5 other commission members. To my left are Vice Chair Andre Bevel and members Lavely Perling and Yuri Gatskin. And to my right are commission members Juliana Civanini and Lillian Ansu. Commission is also assisted by members of its secretariat, and you'll see, Judge, that there are also some members of the media and the public here in the room with us. A photographer took pictures very briefly at the beginning of the session. The hearing is being conducted with translation between Romanian and English. To allow for accurate interpretation, I ask that everyone speak clearly and slowly, and only one person should speak at a time. Proceedings are being recorded. The recordings of the Commission's public hearings generally will be available online at the Commission's website, www.vettingmd.eu, within 3 days after the hearing. During the hearing, one or more members of the Commission may ask you questions. You should answer truthfully and completely. Your explanations are important to the Commission in verifying your financial and ethical integrity. At the end of the hearing, you will be given an opportunity to make a brief closing statement. In posing questions, we will consider your privacy and, where required and possible, the privacy of family members and other close persons. So we will leave out unnecessary information such as identification numbers, bank account numbers, specific addresses, and in order to protect privacy, we would ask you to do the same. I will start by briefly reviewing the evaluation process for Judge Turcan. The Commission initiated its evaluation on the 26th of July 2023 by notifying the judge by email and asking him to complete and return an ethics questionnaire and the financial declarations required by Law Number 65. Judge Turcan returned the completed declarations and questionnaire on the 11th of August 2013. As part of evaluating a subject's ethical and financial integrity, the Commission also obtains information from many other sources, such as the National Integrity Authority, the State Fiscal Service, the General Inspector of the Border Police, other public institutions, financial institutions, and open sources. The Commission assesses the information it obtains for its relevance and reliability. On the 29th of September 2023, the Commission addressed a round of questions to Judge Turcan and asked that he respond by October 6, 2023. He submitted a response by the deadline. On October 19, 2023, the Commission asked Judge Turcan to clarify certain uncertainties found during the evaluation process and to provide answers by October 24th. Judge Turcan requested an extension, which the Commission allowed, and the judge then on October 26, 2023, responded to that round of questions. On November 2nd, 2023, the Commission asked Judge Turcan to clarify certain matters and to provide answers by November 7th of 2023. Judge Turcan responded to that request by November 6th. Subsequently, on the 30th of November 2023, the Commission asked the judge to clarify additional uncertainties and provide answers by the 4th of December. Judge Turcan responded by the deadline. On March 7th, 2024, we notified Judge Turcan that the Commission in its investigation had identified some areas of doubt about his compliance with the ethical and financial criteria. The Commission also invited the judge to attend today's hearing. On March 10th of 2024, Judge Turcan requested access to the evaluation file, and on March 18th, 2024, Judge Turcan received the requested materials. Judge Turcan, to begin, let me ask, do you wish to make any corrections or additions to the answers you've previously provided to the Commission?
Eu cred că e mai bine, în primul rând, bună ziua, scuze.
First of all, good day. I'd like to apologize if I did not fully answer or have omitted anything. I want to wish you good luck and good day. I think it would be best if we could proceed to the questions and I will answer them, as additional information could take time and might be useless. Therefore, I'm open to answer the questions that the Commission will address. I'm not speaking too quickly. Does the interpreter manage to interpret? Yes.
Yes, I think the interpreter is keeping up, and thank you for asking. Members of the Commission will ask some additional questions. We'll try to keep our questions short and to the point, and we would ask that you try to keep your answers responsive and concise as well. Commission Member Andrei Beevil will start with the questions.
Bună ziua, domnul Țurcan.
Good day, Mr. Țurcan.
În notificarea
In the notification for the
au fost comunicate trei
hearings, three groups of doubts were identified that the Commission would like to discuss today. These are grouped as following. So, inexplicable wealth that was accumulated during the assessment evaluation. So, the European Court of Human Rights, where you participated as a judge, and not motivated absence, as of March 2022, and we will address questions for each group of doubts separately, and we will subsequently go through each of the three groups. We will start with inexplicable wealth first. The Commission has identified inexplicable wealth, 1,054,096 Moldovan lei. This amount was formed. The difference between the revenues, your revenues, taxable revenues, and the expenses that you had during this time. The deficit occurred throughout 3 years, 2012, 2013, 2018, and we will discuss each year separately because the deficit was caused each year by some punctual expenses concerning some goods. Therefore, we would like to discuss each of them separately. We will start with 2012. Where your expenses exceeded your revenues with 600,000. We've established that your family had a total revenue of 149,000 Moldovan lei, but a total of expenses of 701,469 Moldovan lei. Concerning these calculations, we have a doubt concerning this negative of concerning this difference. Generally, your expenses or this difference is explained by the acquisition of an apartment of 88 square meters on the Studenților Street in Chișinău, the value of each, according to the contractive, of 622,400 Moldovan lei. Could you please explain what is the stream of revenue that has covered the purchase of this apartment, of this real estate?
Pe marginea acestui subiect, pot să vă informez.
Concerning this subject, I can inform you that the expenses of over 600,000 Moldovan lei were not paid by the family of the judge. The apartment, the real estate, was purchased by the person who lives abroad, on its own name, and with this person's money. I won't name the person, but I believe that in the materials that the Commission and the Secretariat's Commission, the specialists have collected, you will find the information about the fact that the owner of the apartment is married for more than 15 years with a Jewish citizen of Israel. That person is employed in that country, and forgive me, but I was it was not possible to force that person, who actually is a very close relative of mine, but is not a member of my family, and who left for Israel for over 17, 18 years ago, and each time she was thinking about maybe returning or not back to the country as any other citizens of the Republic of Moldova, in fact. Therefore, she has decided to invest the money that she earned in Israel. So I do not know how I could force that person to prove her incomes, her revenues. But I do anticipate the next question, that upon the purchase of the apartment, of the real estate, in the name of the person from Israel, has acted my spouse, my wife. Maybe I won't be believed, but I didn't really know about it. This is how things work in our family, even the most close relatives, children and my spouse. I wouldn't say that they are afraid of their father, but they do avoid informing me about everything, thinking that I'm overwhelmed by my work issues, just daily life. And I do assure you that the respective sum, the negative, is not reflecting any expenses that are mine or of my family's, but is of this person, and the apartment was purchased in her name, of this person from Israel. Yes, Mr. Țurcanu, yes, indeed. Thank you very much that you did not name the respective person, but we can say that this is a close relative of yours. It is your sister. But there are certain circumstances which create some doubts about attributing this purchase this apartment to your family, and these are the following. And I would like to explain this to us. In the respective period 2011-2012, there are no information about the revenue income of your sister in the records of the State Fiscal Service. You've already mentioned that she was already abroad. You've provided some contact details, and the Commission attempted to contact her directly to request information, but did not receive any replies. This person, the lady, did not reply. When the contract was signed in the name of your sister, based on Anatolie law, your wife acted from September 16, 2009, which was issued for 3 years, which is expired in 2012 on 19th of September. At the same time, on the 15th of February 2013, 5 months after the power of attorney has expired, has signed with the mandatory for signing at the land and territory, the authority, the registration of this real estate. So how can you explain the fact that your wife has acted with an expired power of attorney? For me, this is news. In the questions addressed by the Commission, it's news to me, the fact that the power of attorney was expired. I did not inquire about that power of attorney. That's only now I find out about the expiration date of this power of attorney. However, I would like to make the following remarks, and I would like to return to what I've already informed you about. What my sister does, that she wants to invest, to bring her money from abroad. So I was not really informed, or better said, I was not informed at all. That's one aspect. The second, you've mentioned the fact that the fiscal authorities does not present, or that does not have any information about the revenues of my sister, but she's not civil servant, and she did not really honor her obligations of declaring back then her. And it's a well-known fact by everyone that persons working abroad do not declare their revenues, their income to the state tax authority, fiscal service. I believe you understood me. I don't need to. So, who has paid this construction company for this contract? Who has honored this contract? I guess that the money. So this is just what I'm guessing, that it was paid through my wife. I'm not 100% convinced or sure of it. However, indeed, the question arises how the money of my sister were received by my wife, how were they entered into the country without declaring them when crossing the border, at the border crossing point. Probably my sister kept bringing the money in sums that did not require to be declared, and to also send them in cash through her colleagues that she worked with in Israel. Besides, my sister did oftentimes visit us with her husband, a citizen of Israel, and up to 2012, do you believe that your sister has crossed the border frequently enough to be able to bring in cash this entire sum of money? I'm convinced that the sister had this possibility, the opportunity to pass on the money in cash, but I've mentioned that it was not necessarily needed for her to travel to Moldova. She had also the option to send the money through her colleagues, friends who worked and continue working with her and live in Israel. I don't remember now the town, but in Israel. So you've declared during previous written question rounds and also today that your sister is married for many years with a citizen of Israel, so she lives there. How do you explain the fact that another real estate transaction closed in 2021 in front of a notary from the Republic of Moldova has declared that she is not married? She doesn't declare that she is not married in Moldova, but she declared that she's not married at all. So how do you explain this contradiction, you know? I wouldn't want to prejudice the family relations, the personal relations of my sister. I can't know why she declared expressly that she's not married, but I do know for a fact that the marriage between my sister and the citizen from Israel is officially registered not only by the authorities, state authorities, but also religiously, by the religious institutions in a synagogue. I mean, maybe. In any case, the citizen of Israel calls me godfather, marriage. Godfather. Understood. In 2021, the same apartment, through a power of attorney as well, was sold by your wife to your daughter. According to the rules that were already in force in 2021, the seller, so your sister, represented by your wife, has signed a declaration and she confirms that she has received all the financial sources from the buyer, so your daughter. So my question stands, when and how and if at all your wife has transferred the money from this to your sister. Probably this was merely a more formal process, because my
funcționar public.
As a civil servant who works within the Ministry of External Affairs, and she received a loan, which is called prima casa, the first housing or first house. So I think that loan was transferred indirectly or through my wife to my sister. Or I'm anticipating, and I can inform you already, that my sister decided, after all, to not maintain the ownership of the respective apartment, but to purchase a small house in the Stăuceni community village where I live, because coming to Moldova as a guest with the Israel citizens and embracing the climate from Moldova as well. So the family of my sister, so they don't have children, by the way, so my sister and her husband, they have decided that it would be good to own real estate in Moldova where they could travel to any time. Concerning the purchase of the house, we have no questions. The question was if the payment declared by your wife that has received from your daughter, which logically should have been transferred, sent to your sister. So the question is how they were received from the daughter to the wife and from the wife to the sister. I'm sorry. The chair mentioned that we shouldn't interrupt each other, but I think potentially at the notary, because we all know that in Moldova it's just a formal thing when you're signing that you confirming that you've received the payment from the buyer, but the money are not given in front of the notary in cash, and the notary is not questioning how the money was transferred by the buyer. But what I can say, and I've answered previously, that the money, my daughter, I don't exclude the fact that maybe she transferred them directly to my sister without the intermediary role of my wife. I'm not even excluding the situation when maybe my wife didn't even hold those money. So that loan that I've mentioned for young specialists to purchase a new house.
I have some questions. And I have to go back to some detail related to the purchase of the house. The contract was made by your wife based on a mandate given by your sister in 2009. And we have documented that your wife has had mandate from your sister during at least since 2009 up to now. Is this correct that your wife has followed a bit the interest of your sister in the country?
Yes, it is correct. I will provide more answers than you've asked. That's what an American colleague of mine said. I should. So we are talking again about how the money was brought into the country by my sister. So there was one moment that the Commission did not look into and they don't know about it, but between 2009, 10, 11, my sister was sending money through transfers or somehow. So this issue was assessed by the National Integration Authority, Anti-Corruption National Center before. So during those years, 2008, 2009, 10, 11, if I remember correctly, she left in 2005 or 2006. So she was transferring the money to my wife. They have trustworthy relationships, better relationships than with me, although I am her sibling, I'm her brother. And my wife has collected the money on her bank account, on her own bank account. So when the verification was initiated by the NAC, NAI presently, so I didn't know when they've initiated that verification, and that's how I found out that my wife receives from Israel money on her bank account, bank card. So it was a big surprise for me to know about that bank card. Yes, since this will be published online, I'm not going to say it, but there were some misunderstandings within our family, because we are a very friendly family, but I would like to repeat myself that not always my family members are willing to communicate to their father about the actions they take. Not saying that they are afraid of doing it, but maybe they don't wish to overwhelm with worries their father. Maybe they take a pity on me. But my wife, and you've asked very concretely, I'm answering it as well, between my wife and my sister, they get along better among each other than they do with me.
So your wife participate to the contract in front of the notary in January 2012 based on the mandate. And when after the expiration of the mandate, she went to the cadastre for registration in 2013. Was this apartment in Chisinau in town occupied? Was somebody taking care of the bills, electricity?
Probably for the management, for solving all of these issues concerning the use of this apartment, it's obvious that the wife was dealing with that. But as far as I know, the apartment was purchased. So the apartment was bought in a building which was not yet finished, and the nuances about the contracting with the electricity provider, with the water providing company, etc. So this represented a matter which, yes, you had to have time for and reach out to each of these, to go to each of these institutions and to deal with it and to have free time for it. So surely my wife was in charge of that, dealing with that apartment, and probably concerning any final works within the apartment, like painting, etc. Because for me it was a surprise that my sister purchased this apartment. I've learned about it only once the fact was accomplished that my sister is purchasing an apartment in the Republic of Moldova.
Just to follow up, Judge, do you know when the apartment was first occupied by anyone and who that was? When did someone first live in the apartment?
Until my daughter occupied the apartment. I am convinced that no one else lived there, and she occupied the apartment. My daughter occupied it when she purchased it through this governmental program, Prima Casa, First House, when she returned from a diplomatic mission from Poland, and not having a place of residence and having a small child. So she negotiated with my sister, and my sister sold the apartment to my daughter with the goal to purchase a house, because the apartment is in a building, but we, the more elderly, we prefer to have a house, to plant some flowers around, etc.
Well, this in July 2021, so 9 years after the purchase we were talking about, your daughter bought the apartment of your sister, and your sister bought the apartment, the house in the village. Is this correct? And
Corect?
Yes, correct.
Corect.
And your sister was in person in the country at that moment, because she was present in front of the notary, and she arrived with the flight from Tel Aviv.
My sister was in the country not only that one time, but she was also accompanied by her husband. And I am convinced that when my sister has purchased this house from this village, from this rural locality, I am convinced that she was in front of the notary. I was observing, seeing that there are some discussions. By the way, the house, maybe this is not the subject of the investigation, but the house was purchased from a relative that left to Ireland and decided not to return, and she lives in Ireland, and she decided to sell her house. And being close friends and relatives, I think the colleagues from Moldova, they will understand, because we've baptized children, so we've became relatives through that. So it's best or better to sell your house to someone you know than to strangers.
And you tell something about how your daughter could buy the apartment. You made the reference to a governmental program, Prima Casa. Can you explain better how she could afford to buy this apartment?
My daughter continues to pay, so to pay back the loan provided by the government through the bank. I don't know how much she paid so far. I didn't look into that, because my daughter is currently abroad in Washington, but she continues to pay back the loan, anticipating that potentially that for the apartment, not only the sum of the loan was paid, but also additional money was paid. I do not know if additional money was paid, but I do know quite well that the husband of the daughter, who is not a civil servant, in fact, but being an ambitious man and feeling himself obliged to contribute to the well-being of his family, he also contributed to this purchase of this apartment.
I'm done on this issue.
Eu mai am două întrebări de clarificare.
I have two clarification questions about 2012, and then we'll move forward. So you have communicated that there is some probability that the money received for the apartment to be redirected by a sister for the purchase of the house. However, the house was purchased before the apartment was sold. So the house was purchased in June and the apartment in July. So we have 1 month between these two purchases. So
A fost documentat?
it's possible that the fact that the house and the apartment were purchased with this 1 month difference was documented, but to document it, so the paperwork and to actually transfer it, because it's not, I'm not excluding the fact that even the relative from Ireland, but also the daughter and the sister, they have negotiated, and when they've transferred the money, maybe this took place in the fall, in September, in October, based on this trust-based relations. This is what's it about. One more issue to clarify. You've just mentioned that before your daughter occupied in 2021 the apartment from the Studenților Street. Nobody lived there, no, nobody. And your sister never lived there either. Yes, my sister purchased, as any other citizen of the Republic of Moldova, to have some backup to return to. So we will move forward to 2013. The Commission calculated a difference between the revenue and expenses of 181,373 Moldovan lei, so total revenue of your family in 2013 were of 136,907, and the expenses are over 300,000, so we have a negative balance. And one of the main expenses that was registered was the purchase of a vehicle, Mercedes E-Class, manufactured in 2006 for 200,000 Moldovan lei. Throughout the evaluation, you've declared that in 2013 you've also borrowed from the same sister you borrowed this amount of money based on a receipt in order to purchase this vehicle. Could you please tell us from what sources was your sister able to give you this loan in 2013? In 2013, my sister already had She already had worked in Israel over 7 to 8 years. So surely, if we will calculate this amount, 200,000, according to the currency exchange, let's say in US dollars, so this is around 10, 11,000 in 2012, in 2013, no? Okay, maybe 12,000 US dollars. But I did not ask my sister where did she take the money. I just asked her if she can lend it to me, and the family also accepted, her husband also accepted to do it. She didn't, he didn't only accept, but he insisted on me doing so, because as my sister has very close relationships with my wife, I think the citizen of Israel holds me dear in his heart. We're very happy for you. So we do understand that this was given in cash. How were they sent to you? Did you travel to Israel? They were at that moment in Moldova. I think that it was my sister, I think, yes, this sister, in Moldovan lei or in another currency. Yes, they wanted for this receipt to be drafted in Moldovan lei, but the money was were given to me in another currency because I already had an agreement with the owner of that car concerning the purchase, and my sister, knowing that person and knowing about the negotiations, so she offered that loan to allow me to purchase it. How did you return that loan? Shamefully, unfortunately, I didn't return any dime. Maybe it's not accepted in the civilized world, but here debts sometimes are forgiven because we are 5 children in our family, and none of us wanted to share the inheritance left to us by our parents. So I will never, so this was the aspect that we will never want to have any interest to get that share of the inheritance. The second thing is that when they were traveling to Moldova, that citizen of Israel was never living in a hotel. They were living with us. They were not paying for food while in Moldova. They were not paying for transportation while in Moldova. So they were, or he was insisting on making gifts. So discussing about it, they insisted, and they said, forget about those 200 or whatever, 12,000 US dollars. That receipt was destroyed. So the loan became a donation. Yes, after some time, yes, it became a donation. However, at the respective time when it became a donation, the vehicle itself was already sent for parts, so it was not usable anymore. Okay, so let's move to 2018. In 2018, we have a similar situation to 2013. The expenses exceeded 272,000 Moldovan lei. This occurred after a total revenue of 441,000 and total expenses of 617,000. So here we have one of the biggest expenses of your family in 2018, which is related to the purchase of another vehicle, Mercedes E350, manufactured in 2014. This vehicle might have been bought in 2018 by one of your sons-in-law, and it is registered and declared in 2018. The price of this vehicle is estimated to 538,000 Moldova lei, or 25,700 euro. The period prior to this purchase, we are talking to 2011-2018, your son-in-law, the taxable gross income of 1,138 Moldova lei, so it was impossible for him to cover this purchase. In 2016, he got married to one of your daughters, and the Commission took into consideration the income of both spouses, and this cumulated income represented 111,432 Moldovan lei, or over 5,000 euros. So their taxable income wouldn't have been able to cover that purchase. So the question is, what was the source that was used to cover the purchase of this vehicle? I will start by knowing the purpose of purchasing this vehicle by the son-in-law. The son-in-law purchased this vehicle with the purpose of selling it or reselling it. But according to the national legislation, the persons who have benefited from waivers of paying import taxes. So for 3 years after purchasing the vehicle that was imported to the Republic of Moldova, you were obliged to keep the ownership of, so to not sell it. So persons who have worked in diplomatic missions for 3 years, they had the right to import 2, then 1 vehicle, and currently they are not allowed to import any vehicles. But when the legislation was amended, they allowed the import of only 1 vehicle, and then subsequently even that vehicle, it was allowed to sell that vehicle only after 3 years passed from the imported date. So, but the import tax, I don't think I have to name it, but it's actually a considerable sum. And the son-in-law, he still is considering selling that vehicle, but he is currently serving on the 3rd diplomatic mission in Washington, D.C., the Embassy of the Republic of Moldova. And when they will return, or if they will be back only for holidays, probably they will sell that vehicle. But in order to anticipate your question, because I've read in the documents that the Commission collected, why is this vehicle, why Anatolie Țurcan is driving this vehicle, the son-in-law, obviously, so has, because we live in a house and we have a courtyard, so we have space for that, so they left the vehicle for us to keep it. And besides that, the son-in-law has insisted for this vehicle to be used, not to be just kept. So yes, I do use this vehicle, but it is the ownership, in the ownership of my, it's owned by my son-in-law. So yes, I just wanted to answer to this. How did they have the financial means necessary to purchase it? I don't have the right to investigate the revenue of the son-in-law, but since he is not a civil servant and being the only son of his parents, a single child, and being a very active person as a young person, and I already mentioned taking care of the well-being of his family and the maintenance of his family. Indeed, I guess he obtained revenues that he did not declare. However, I cannot, and the law does not allow it either, but also common sense, to force the son-in-law to describe it to me how he has made that money. But I can mention that from his biological father, after he passed away, he inherited a 2-room apartment. I know this fact. They were very happy. Well, not very happy. They were sad because the father passed away, but they were happy because he was richer by 1 apartment in Chișinău. So the son-in-law is not a person who could live on 1,000 Moldovan lei. That's obvious. It's evident. You've just declared the fact that the vehicle, the car, is in your courtyard. You are constantly using it. From the information received by the Commission from different institutions, we've concluded that in the last 2 years you've crossed the border as a driver 14 times with this vehicle. You have purchased the mandatory insurance and also the international green card insurance, car insurance. You have been also sanctioned by some infringement of the
chiar la 6 martie 2018,
in traffic, some traffic infringements, and when it was registered with the Agency for Public Services, this car, you've submitted a request, it's signed by you, you've requested for this registration certificate to be issued as an usufruct. Could you please explain this, considering all of these circumstances in usufruct, why this vehicle is not identified in the NAI for 2018-2020?
Decât ca o misiune a mea și culpa mea este vina mea.
Maybe it's my fault.
Știți, poate greșesc, dar
Maybe I'm wrong,
încă
but
nu era stabilit clar
it was
modul de
not
completare a
yet
declarațiilor.
clearly clarified how the declarations have to be fulfilled. So there were some rumors, also some
Este declarat
acquaintances from the fiscal service that once a good is declared by a person, so the owner,
declararea repetată.
the repeated declaration of it is not needed. Maybe I've omitted something, I'm not denying it, but to be usufruct, it doesn't mean that you are the owner of the good. So we're not contesting this. The idea was that law 133 about interests and wealth, that there is an obligation for the judges to declare also the goods they are using as usufruct. This was corrected. I've corrected and I've started declaring it. Maybe you've noticed. I've started declaring it before the evaluation exercise started, not knowing that this procedure will start.
To know if you provide for the insurance of the car since it was bought until now.
Sigur că da.
Yes, sure, because the owner, the son-in-law and my daughter, after the diplomatic mission from Warsaw, from Poland, they were in Stockholm, sent to Stockholm on a diplomatic mission, so they were not present in the country. And when they returned from Stockholm, they were sent on another mission to Washington. So I had to honor these obligations concerning the mandatory insurance. When mentioned the deputy chair, when I was crossing the border, I had to purchase this in green card, international car insurance, etc. So it was an obligation to do this. I was obliged to do it, and indeed I have purchased these insurances, this green card, everything that is necessary to use a vehicle. And the reason for that is because the son-in-law, yes, there was a modality to do it through a mandate, through power of attorneys, but this was not necessary. When I was able to buy them directly, these insurances, I mean.
Judge, before I move on, is this Mercedes, is this kept at your house?
Da, sigur.
Yes. It's in my courtyard, the courtyard in that village, in the courtyard of my house. It's a logical thing not to put it on a parking place, because if my son-in-law would have left it in a parking place, that would cost him. By the way, the son-in-law will, in summertime, he will return to Moldova, and I am not excluding the possibility to purchase a vehicle for myself on my name, that I would be the owner of. either based on my pension or taking a loan for it.
So if I've understood the information you've provided in your responses to our questions and what you've said today, you've been the primary user of this car since your son-in-law purchased it. You're the one who drives it, pays for the insurance, and is registered as the permissive user, correct?
I can't really say that I'm the main user, because each time when the son-in-law returned back home, and even during these trips outside the country, when I went to Romania to some balneary, so yes, the user was the son-in-law. So when the son-in-law was present here in the country, he was using it anytime. There were a few attempts to also sell it, but I would like to reiterate that the legislation has did forbid it, because for 3 years you are not allowed to, because you've benefited of this import taxes waiver. So the law provides for this. So if you have used this waiver, then for the next 3 years you cannot sell this vehicle.
Thank you.
One last question to this aspect. We do understand that your children that we talked about so far, so they have enjoyed the facilities of the members of the diplomatic body of the Republic of Moldova. When they return from a mission, they can enter a vehicle, so facilitated by this waiver of import. But in order to facilitate and avoid abuse, the person is obliged to keep that vehicle in their ownership. To avoid transforming it into a business, they have to keep it for 3 years, and then they are allowed to sell it. So the respective vehicle was brought into the country in January 2018 and was registered with the Public Services Agency in January. So 3 years have expired in 2021, and since then 3 years more have passed. So in the last 3 years. So my question is, if the intention was to sell this vehicle, why didn't you sell it in the last 3 years when your son-in-law has the right to do it? Probably the correct answer, the question should have been addressed to my son-in-law, but I will try to answer it. As far as I understood, the son-in-law, since 2021 until presently, so as you've mentioned, 3 years passed, did not sell the vehicle due to the fact that the respective vehicle brand, so their price is not going down, so he does understand that he's not risking for the price to go down. So besides, it is possible that maybe the son-in-law waited and is waiting until summer for the father-in-law, so the person using this vehicle to be able to put together some money and purchase his own vehicle. Other explanations, just suppositions. I don't know why he didn't sell it. We know that there are different life events, and besides this, for this process to happen, to sell the vehicle, one should be physically present. In your family, you have this tradition of representing other family members through powers of attorney, so it wouldn't be difficult for this process to be repeated in this case. So you mean that the son-in-law could have signed a power of attorney on my name, or as tradition says, on my wife's name? Yeah, I agree with you, this could have happened. Especially since by selling the vehicle, the son-in-law and the daughter would then have the opportunity to pay back the loan ahead of time, that loan they received from the government. However, they did choose to pay the loan as the law allows it in installments, and probably it's not rational and useful to pay the loan, to anticipate the payment of the full loan, of the partial payment of the loan. I've mentioned already, I was informed by the family of the daughter that they don't exclude so the probability is very high that they will return in summer and they will sell this vehicle. The time has come for that. Mr. Țurcanu, you've mentioned that you have pretty good relationships with your sister. She visited your wife, represented her in front of the notary for a real estate transaction. So maybe you know, maybe this was issue discussed within your family concerning justifying financial resources in front of a notary for the purchase of these two real estate, so the apartment and the house from Stăuceni. According to the present legislation, the buyer has to justify the revenue or the source of the money. So I'm working on criminal cases, not civil cases. However, as far as I know, when in 2013, 2014, real estate was bought, the prices, from what I know from the practice here in Moldova, the real prices were not indicated. So the prices, the costs of the respective goods. So concerning presenting the information about the income sources, in our country, the buyers of real estate had, at least throughout my lifetime, addressed this more as a formality. Differently put, they were able to provide different types of justifications, and notaries weren't requesting information about the sources of income. Later on, and after the house was purchased, when the house was purchased, notary offices started to request information about the sources of income, but not so much even then. Only presently in the Moldovan legislation, we have mandatory provisions that foresee that I think that transactions that go over 70,000 in a different currency to be conducted through bank transfers, as far as I know from TV, because to be honest, I'm not a specialist in civil legislation, but more or less I try to be up to date. Did you personally see any documents that were presented by your sister? I cannot state anything. You mean in front of the notary, right? Yes. So this is an issue between my sister and the notary, and I've already mentioned that the members, my family, you've said that we have close relations with my sister. To be honest, I call her that she has a different nationality, that her that after 18 years of living in Israel, she's now having a very specific character. But she's the youngest. We are the youngest out of 5. So may she be happy and blessed, and the parents too. Mr. Țurcanu, this ends our first session of or round of questions on the first group of issues. So the decisions of the European Court of Human Rights against the Republic of Moldova. You've participated at the national level as a judge. Based on the information received by the Commission from the governmental agency, you have participated in issuing certain decisions in 10 cases that reached the European Court of Human Rights, and there were infringements, findings identified as well. So in these cases, in these 10, so Savka, Mitrofan, Ghirea, Dan, Sara and Dimitreva, so 6 of them, the decisions issued by you were issued outside of the evaluation period. So 10 years, over 10 years before the evaluation period has started. Therefore, these 6 will not be taken into consideration for the evaluation of ethical integrity. Manole, you were part of the SCM, but the infringements are referring to the Supreme Court of Justice, respectively in this case neither the Commission will not review it, but there are 3 cases which are foreseen, which are assessed during this evaluation period. So Dubalar, 14th of December 21, Melega, 18th of January 22, and Nadur against Moldova, 2 decisions, one of 2019, one of December 2022. In all of these 3 cases, the infringement of Article 6 was found by the court of the right to a fair process. So all of these cases are similar, if not even identical. The issue identified by the court is the following, is that the plaintiffs were convicted for some crimes and they were, then the appeal court Deci a fost... We will continue. So in these 3 persons, these were persons that were accused and sent to court where the judges, the court have acquitted them, and then they contested during the appeal procedures. These persons were condemned by appeal courts without being without hearings being organized in front of the court of the witnesses. And you've participated as a judge of the Supreme Court of Justice, and in all of these courts, the Supreme Court of Justice did not solve these issues or did not take into consideration these arguments and did not examine the arguments and their right for a fair process, and especially for the witnesses to be heard in front, live in front of the court, was not observed. So when you participated, when these 3 causes, Dubalar, Melega and Nadur, did you know the provisions of Article number 6 and case law of the court for Dimitreva and Dan against Moldova cases which had similar infringements? I will refer to all 3, and your question, if I knew the case law of the European Court of Human Rights concerning this issue, yes. So I will start by informing you, and that's why I requested for a closed hearing concerning this aspect, but I will try to avoid prejudicing, or not, better said, not influencing the justice process in the Republic in general.
Aveți perfectă dreptate.
You
când
are right, you are
menționați că
perfectly right when you are mentioning
instanțele ar
that
trebui să țină
the
cont de
courts
procedură.
should
Așa, să mai
take
prim simplu.
into account, and I will use
Condamnare. Adică
plain
instanța achită,
language, so acquittal and condemning.
este o problemă
It
actuală
is a current, present issue.
în prezent. Instanțele
Until now,
de judecată din
The
Republica
courts
Moldova
of law in the Republic of Moldova
deseori
are oftentimes
impuse în situația
forced
situație de imposibilitate.
or put in a impossible situation of having to observe the procedure of annulment of acquittal and condemning cases. Why am I saying this? Because as a judge, I know the situation quite well. When during the Court of Appeal sessions, the prosecutor is supporting and they are insisting on convicting the person. So studying the case, the judges see that indeed
Sunt destule
there are many,
circunstanțe obiective
there is evidence, objective circumstances
soluția de condamnare.
which imply that condemning is necessary. However,
Nu cere acuzatorul de stat. Nu cere cercetarea
however,
de
the the prosecutor does not request, and the attorney even more so, because they have in front an acquittal solution. And in such cases, the superior hierarchical court
impusă să se afle
The
între Sila și Haribda, între Ciocan și Nicovală, între
is
două
basically
dileme. Că, de
put
o
between
parte,
two
suntem convinși,
dilemmas. So on one side, we are convinced because the court has its conviction that the interpretation and the application of the law shows that the respective person
vinovată. Mai ales când merge vorba despre acte de corupție,
is, especially if we talk about corruption, and we talk the attitude of international bodies, and we know the fight against corruption around the world and in Moldova as well. And we, maybe I will not express myself correctly, but we are risking sometimes, concerning the three causes, the three cases. I was afraid that you might ask about previous cases, and it's good that you are not going into those, although I've provided explanations starting with the first case. So the first, I'm not going to say the name were incorrectly, just to mention it, because I've named it, it's incorrectly named that Țurcan has decided on extending imprisonment. Țurcan participated only once on maintaining the application of imprisonment. But let's return to the three ones you've referred to. So Dubalar, Vega și Nadul, yes, I was the member of the group of judges, 5 judges, for the 3 cases, and I do acknowledge the fact that there is my fault, maybe because I did not issue a separate opinion, because during the deliberations, so when we voted during the deliberations, then it was an unanimity vote, so I had the same opinion as my colleagues. And going to the Dubalar case, it had been examined by the recourse annulment recourse, so not ordinary recourse procedure. And the annulment procedure, so I'm not going to disclaim the secret of deliberations, but the penal code, the criminal code foresees that at the time if 5 judges are assessing it, it's enough for one of them to insist on sending the case to the criminal plenum. And it is strange that such a procedure was indeed included in the criminal code, but it is sent to a 7-8 judges court. But it's obvious that if 4 judges are for or are against it. The fifth one insisting, because you cannot issue a separate opinion in this case. So either you are voting unanimously, or either you say it's inadmissible, or you are sending it to another court. But when I've joined the Supreme Court, usually, most of the time when I was in the Supreme Court, we had 8 judges, and it was obvious that you have 4 against, and definitely you will find a few which will be against it, so it's useless. So yes, this is a gap. Yes, this is a gap of the criminal process, penal process in the Republic of Moldova. I'm not going to criticize the international body, but I think that these should be foreseen on repeatedly citing the witnesses. And Mr. Țurcan, you have anticipated actually many questions. However, I would like to return to the general questions. So I do understand from your answer that you did know about the case law of the court. And from what I understand, you do accept that the case law is mandatory for the judges from the Republic of Moldova. So they have to observe it. Concerning dubelar, talking about a specific part. So the Commission, indeed, you have participated in the annulment procedure, not in ordinary procedures, but the annulment recourse. But this annulment recourse was submitted by the General Attorney, prosecutor, after it was communicated by the court. So not when a presumption existed, but a very high probability that a condemnation order will be submitted. So this national remedy was attempted in order to attempt to avoid the condemnation of the Republic of Moldova on an issue that we were oftentimes condemned on before that. So my question is, do you believe that if this annulment recourse would have been admitted, could the condemnation of the Republic of Moldova be avoided on the respective case? I will use my right to opinion and will insist on no, it wouldn't have been possible to avoid it by accepting the annulment procedure. It wouldn't have been avoided the condemnation of the Republic of Moldova by the European Court of Human Rights. By the way, maybe I am... but let's not use this formulation, condemnation of the Republic of Moldova, the European Court of Human Rights, because the Republic of Moldova is not condemned. The European Court of Human Rights is just establishing the fact of the not observing or infringement of not fully observing the rights of a person in Italy or in other countries or in the Baltic states. As many times as I visited them, I was asking them if they use this expression, this formulation of being condemned at the European Court of Human Rights, and they were asking, why are you using this formulation? I'm sorry, Mr. Vice Deputy, I'm sorry, but this is hard to hear, condemnation. Yeah, well, then they have to establish also the punishment, I guess, so that's the last thing for them to do. In the Baltic states, they don't use such formulations. I do understand that criminal law is your specialization, so it's a sensibility here, a sensitive word. So, concerning dubelar, so the court has issued a decision establishing this infringement by the government, by the state, of the rights of the person, and the decisions were reviewed by the Supreme Court, who initially has refused the annulment procedure. So, when I'm not probably divulging, but when we were...
Then you start again the answer because the translator was
Understand?
lost because of the overlap. Thank you.
So, when they were discussing admitting or not admitting the annulment recourse of the general prosecutor. The government was only notified at that time by
E clar, despre dosar. Nu exista
about this case, about this file. There was no decision of the European Court of Human Rights in place.
Nu divulg secretul de preț.
So, no, I'm not divulging any secrets. We are evaluating, assessing the materials pertaining to the case, and we've reached the conclusion that it is prematurely so to discuss, or to not to discuss, but to admit the recourse, the annulment recourse of the prosecutor's office, because we did not know yet in the human rights case law, the European level, there were cases that even if the government was notified, in the end, the European Court was not and to some point the judges were guided by this hope that maybe the government will not be condemned. So you understood what I meant. Okay, let's move to Melega. The plaintiff was, I think it was traffic of influence, corruption allegations. So the first instance, so the court has indeed heard all the injured parties, has rejected an audio recording because expertise showed that they cannot confirm that the voice did not pertain to the plaintiff, and has acquitted. And again, the appeal court, without hearing the waiters, again accepts this recording as evidence and condemns Melega. So the court just rejects the recourse without appreciating the arguments concerning the condemnation, the appeal condemnation, without live hearing of the witnesses. Subsequently, the court has identified that Article number 6 was infringed, and a revision application is submitted, and the Supreme Court is admits the revision and another previous decision, the decision of the Court of Appeal, and resends it to the Courts of Appeal. In this case, talking about this particular infringement, the court in the Melega case stated that the appeal court had a positive obligation to hear, to organize the live hearings of witnesses, even if the plaintiff did not request it, because the solution would have radically changed from acquittal to condemnation. So, to condemning. So the question is, what is the reason that the Supreme Court, in the group of judges that you participated, did not use this procedure, this practice of the European Court of Human Rights that was already well established? I understood your question. You've already mentioned that the European Court has motivated its solution by the fact that regardless of whether so if the defense has requested the repeated investigation of the evidence, the appeal court had to proceed with the repeated examination of the evidence when it is evident that the solution will be changed from acquittal to condemning. So if the court discussing or debating, because you said that I can answer in a general way, right? So I'm doing it. So generally speaking, the judges are guided by the fact that if the court ex officio is proceeding, I want to emphasize ex officio, so without a request, so it proceeds with assessing from its own initiative the evidence. It is clear that the court intends to change the solution for the defense, especially for the defense, it's obvious, until the recusal can be submitted, but endless recusals, because the court of law shows a lack of impartiality, so it's biased. It would be good, so as a solution, and thank you, you complimented me that I am a criminal judge. So Article 15 from the Criminal Code, it should be imperatively so. We should, so when we won the cases and in other cases, and there was no imperative norm foreseeing that the Court of Appeal does not hold the right to base its solution without looking again at the evidence. So this imperative provision was included in the Criminal Code only after the European Court of Human Rights have found this fact of infringement of persons to defense. Respectively, presently, it's not too late, and we should request this to the Ministry of Justice, Parliament and Government to add one more paragraph in the respective article concerning in the Penal Code. So you've seen, Mr. Chair, that the European Court has mentioned, regardless if it was requested or not requested, the assessment of the evidence, the Court of Appeal had to do it. This is the opinion of the European Court, and we have to honor it and observe it. But I provided the justification, the argumentation that if the Court of Law proceeds with the ex officio assessment, regardless if the participants, so the plaintiffs, the defendants, have participated or requested it for the evidence to be reviewed again, so doubts about impartiality will appear immediately. And I've mentioned it already that we are between two dilemmas, the Court of Law. Because when I was younger, a young judge, the legislation and the criminal process, the penal process, meant for the courts to be proactive. Then we've reached to the other extreme, that the judge has to actually be a piece of stone and not manifest any type of activity. But later on, in practice, it was shown that the Court of Law could ask clarification questions. But indeed, the best is to find for the Court of Laws a clear role. So it shouldn't be too active, but it shouldn't be passive either. But, as you said, my opinion is that we have to change the legislation. And I don't deny it that potentially, and I accept the fact, I have showed insufficient perseverance in adopting the decisions in the case of Dubalar Melega and Nadur. I had to be more insistent, more perseverant, but to justify myself, I would like to, in front of the Commission, I would like to say that, so I'm my own defendant, but oftentimes I've written actually separate opinions, and I've tried each time for the separate opinions that are published actually with the decision that is adopted, to not bring any prejudice or unclear aspects concerning the application of the criminal legislations. You know, separate opinions, some read them sometimes and they are guiding their actions based on it, and it's affecting the justice, because separate opinions, I believe that we should be very careful, to be very diplomatic. I think that's the correct expression for it. So I do hope that you understood. So yes, we do understand your answer. The Nadur case, a similar cases, the previous ones, with one exception, one small exception in this case. So again, the plaintiff, without the rehearing of the witnesses during the appeal, but the Supreme Court of Justice, during the first round of the recourse, admits it and is establishing that the appeal court will respectively assess again the evidence or request to the relevant authorities to present new evidence. So it returns to the appeal course, and this they again condemn, so they basically copy-pasted the same decision without any rehearing. So, and then you, as part of the panel of judges, you are recusing it, and you are mentioning in the decision that the declarations of the witnesses were read and the parts did not have any objections in the appeal. This case also led to finding that article number 6 of the convention was infringed. And I think that I will close with one final question. Your position, your general position, is that condemning during an appeal without the live hearing of witnesses, does it represent an infringement of article number 6 and of the case law or not? I already mentioned that looking at the realities of the Republic of Moldova, it is a very difficult situation, the rehearing of the injured parts and of the witnesses, especially if we are talking about human trafficking, concerning the trafficking abroad of persons forced to provide sexual services or labor. These persons, it is very difficult for the prosecutor to bring them to the court. That's why we didn't foresee this possibility of forcefully bringing the injured parts or yes. Or we cannot make an international search of these injured parts because you are infringing their rights. Concerning Nadur, and you reminded me, and old age. So I do remember that there was an attempt, even of the Supreme Court of Justice, I don't know how to say it better, but we tried to see if the version of when the parties, and maybe you've noticed, Mr. Chair, you've said that they read, and in the decision of the Supreme Court of Justice we've mentioned that the declarations were read from the prosecution, so the declarations of the witnesses and of the injured part, and there were no objections. The lawyer, the defender, and the prosecutor didn't have any objections, of course, because they were happy to get a condemnation. But we were guided by this and thought that maybe the European Court, maybe they refine, improve their practice and accept that in the Republic of Moldova not always it's possible to bring repeatedly witnesses or injured parts to the Court of Appeal, because it's a very difficult situation, and the Court of Appeal attempted so they have condemned by reading the declarations. And the penal code, the criminal code, foresees in some cases the possibility of reading out these declarations when the person has deceased, when the state prosecutor, for example, to avoid re-victimization, when we talk about hearings, the hearings of an injured part on a sexual abuse case conducted in special conditions, and the defense then invokes arguments that hearings in special in special conditions was conducted with very serious infringements. Yes, but just to clarify, none of these three cases did not actually include such situations. We've seen the folders. We didn't see it's not about human trafficking or such crimes. They're all, one is abuse and the rest corruption. But from the same article of the criminal code, and based on what we understand, there is no proof of the fact that the courts of appeal did not make any efforts to organize hearings of these persons. I am sure that the courts of appeal have not avoided and giving the opportunity to the parts to present the parts of the injured part and the defendants. I don't think that I shouldn't say more, but actually presently we still have cases at the Supreme Court when in the Supreme Court of Justice there are cases coming in through ordinary recourses, and they invoke namely the fact that the appeal courts are not observing this procedure. The acquittal condemnation procedures are not observed. The neighboring country, Romania, was condemned not only for the infringement of the acquittal conviction procedure, but again, I'm saying that we shouldn't use this expression, but I'm still using it anyway. So this was found, the infringement of the rights was found when the first instance has qualified using a mellow article, and the appeal court has framed it within a harsher article, and the European Court of Human Rights has found that in this case too, they should observe the procedure if from one softer condemnation they change. So it's not acquittal condemnation, but it's about condemnation. So simply the harsher punishment is applied. So this is a justice process that still is needing a lot more time for the Republic of Moldova to improve. Mr. Țurcan, we've reached the last issue, and this is about your absence from work, based on the information that the information has collected. So March 7th, 2022, you did not motivate an absence for the whole day. So this was notified, this absence was notified by the SCM by the judge at the time, and according to the border police reports, at 5:36 you have crossed the terrestrial border of the Republic of Moldova to Romania, and you've returned on March 13th, 2022. So this absence from work is confirmed, and from what I remember, you did not contest this. So yes, so this is this is a clear fact that you were not at work. Letter 964 of 22 March 2022. So the SCM was notified that the absence from work did not lead to delaying some of the cases, some of the causes. However, the interim president has mentioned that the work of one of the judges of the Supreme Court of Justice does not refer only to participating in the actual sessions of the court, but also receiving the calls from the Chancellery, naming the cases, studying these cases, participating in examining within the panel of judges, and also redacting and justifying the decisions. So the interim president of the Supreme Court of Justice has also mentioned that immediately after returning from holidays on March 15th, 2022, the panel of judges you're part of has delayed two of the causes where you were rapporteurs. The information concerning the delay of these two sessions is confirmed by the data from the informational informational system of the Court of Law, and the President of the Court also mentioned that because the absence was not justified, it was not possible to create the panel of judges for the emergency cases concerning preventive measure application name. Moreover, they have mentioning that your absence has impacted negatively the image of the judge status at the Supreme Court of Justice. The Commission has also received the work plan for March 2022, where it's indicated that on March 7th you were not present at work. At the same time, you did not submit a request for a holiday on the respective day, or you did not provide any justification or arguments, or you did not inform the entity you worked for that you will be absent on March 7th. So this entire issue was assessed by the Commission using the ethical integrity criteria concerning that the law on the disciplinary accountability, Paragraph H, Article 1, foresees that one of the infringements is the absence without objective motives from work, and if this has affected the work of the court, the activity of the court. As we have clarified that this absence is not contested, could you please communicate what was the reason for not being present at work? This was an attempt of the judge of the Supreme Court of Justice to start this disciplinary action against him. I will not try to justify the absence of March 7th, 2022, absence from work, by mentioning other colleagues, because these would be childish actions to point the fingers at other people. However, the judiciary inspection by the SCM investigating this absence from work found that there was no disciplinary infringement. Take into consideration that even after the inspection has adopted a decision of not starting a disciplinary action, someone insisting a lot on it tries to prove that yes, the activity was not affected, but maybe it would have been affected if a transfer request would have been. And by the way, the Penal Code does not even foresee the transfer of folders of cases. I will not even mention how many persons were absent from work on March 7th. As I said, I'm not going to point fingers, but I will emphasize the fact that for March 7th, I was not paid. In front of this honored commission, in front of you, I've mentioned one of the facts I want to reiterate today. In civilized countries, when I visited the United States of America, we were notified not to give unpleasant questions to other colleagues, judges, but the current president of Northern Carolina, of the Supreme Court of Justice of Northern Carolina, he intuitively felt that we want to ask about the payment for judges, and he smiled and said that the judges of USA are not paid with monthly salaries, but annual salaries. I don't know, maybe in other states is different, but from what I know, in other countries, like European countries, judges are not, I don't know if they don't have a table by the accountant, so registering the participation of the 8-hour day work. They work during the weekends, during nighttime, daytime, etc. So I've addressed the commission and told them that the 8 hours work approach, this is a Soviet times approach. This is a formality that still remains in place. But without taking too much time, I just referred to the fact that someone was interested to start a disciplinary action against me, and that someone insisted that on March 15th, there were 2 cases delayed due to the fact that the judge was not present at work on March 7th. This morning, I picked up the list of files of March 15th. There were 6 examined, that someone does not say how many. He just said that 2 were delayed. Only 6 were examined by a 5 judges panel. Out of those 6 examined cases, 4 decisions were of the rapporteur, Anatolie Țurcan. And if we look at the minutes for 2022, 2023, I think it is clear what I mean already. So concerning affecting or impacting the image of justice from the Republic of Moldova by this absence from work, I'm not sure. Concerning the 7th of March absence, I came to the CMA and I've given them a rhetorical question. Do you want us to see the video recordings and see who came to work on March 7th and who did not? And regardless of this, they did get their salary, but I didn't pretend on being paid for that date. But let me finish my justification. Let me defend myself. So it was a confusion because the government of the Republic of Moldova has developed a bill or a decision that March 7th will be a free day linked to the International Women's Day, 8th of March. And this international trip was planned, my trip was planned. I informed a colleague I asked a colleague to inform the interim president about my trip. And there is this note from the chancellery. So the president has issued a disposition through which he created 2 panels. So the panels were full. There was no risk of not examining this transfer of cases for that particular period of time. My colleague, due to lack of time, or maybe he did not manage to find the interim president and did not communicate to him about my 7th of March absence from work. But yes, let's admit this was that I've omitted this thing. It was my omission, the fact that I did not mention that. But I do assure you, esteemed Commission, that I did work. So out of these 6 cases, 5 judges, 4 decisions reported by Țurcanu, by the judge Țurcanu. Okay, so let's make a conclusion. So your arguments. So I just want to make sure that I understand you correctly. So this absence did not impact the activity of the Supreme Court of Justice. Yes, absolutely, it did not impact. In no way. I won't go into details about this denouncement of...
Judge Turcanu, I'm just a little confused by your reference to the International Women's Day in 2022, because I understand that was on March 8th. So I'm just not sure I'm understanding what you're trying to say about the proclamation and how that relates to the absence on March 7th.
nu o să intru în calendar să trec timpul.
Yes, I won't look at the calendar not to waste any time, but
Chiar de anul anterior și întotdeauna.
the 8th of March, it's a free day because it's International Women's Day. And 7th of March
este o zi de lucru,
is a working day, however,
Guvernul Republicii Moldova
not only this year, but the government of the Republic of Moldova has this practice of deciding that, for example, May 2nd, other days that are
între zile de odihnă,
in between the weekend and the holiday. So there is a working day between the weekend and the holiday, in order to give the opportunity to civil servants to use not 2 days, then subsequently 1 day, and between those 3 days, 1 working day. So oftentimes the government declares that working day is free. They adopt a decision, they transfer the day, and they mention in these decisions that 7th of March we will consider it a free day, and we will work on one other Saturday on the account of that working day. So the working day is not being eliminated completely, but is being transferred to another day, to a Saturday. Mr. Vice President knows about this, and it was a surprise to me because I did not know that the government will not adopt such a decision. I think they have objective reasons for doing that. And the day of March 7th, incidentally, I don't know, remained a working day. That's the situation. So I was not ill-intentioned. It was to have this absence at work, but this trip abroad was planned. Actually, we have had plane tickets as well, and if they would have verified, they would have seen that we've purchased the plane tickets from Bucharest on my name, Anatolie Țurcan.
Okay, thank you, Judge. It seems that completes the questions by the members of the commission. Do you have anything else that you would like to say by way of a closing statement before we wrap up the hearing today?
Știți, nu m-am pregătit.
You know, I did not prepare one, and I don't want to say things that I didn't reflect on. You know, judges are usually putting their thoughts into writing. Am I right? So I'm sorry. I wish you a good day and successful activity in the future. But in the end, I think I should probably say nothing. I can't say much more because I didn't prepare for that. I didn't prepare to speak.
Well, and to be clear, we don't expect a statement, but we want to give you an opportunity to make one if you wish. And I understand what you've said about not wanting to speak off the cuff.
I can only declare the fact that I honestly, really honestly, I wish for the law to rule in our country. And I will answer not so much to the Commission, but using this opportunity and understanding that this will be posted, published online. So I want to address those that are accosting me with questions about why I did not submit my requisition. So those who will have comments to your recording, so I would like to answer why I didn't submit my resignation. So I would have felt that I've betrayed my children if I would have submitted a resignation and not present myself in front of you. I don't want my children to consider me a traitor. I would betray them personally. I have 4 children. None of them studied law in order not to prejudice the image of their father, in order not to be blamed that maybe they are benefiting from their father's protection, etc. I'm sorry, forgive myself that those who will comment will make nasty comments against me. I would really like to meet them, not face to face, but in public spaces with cameras around, and they could ask inconvenient questions, as inconvenient as they want. And I don't know if honorable members of the Commission, you read the comments, but you should know, and I assure you, that not oftentimes the comments are realistic or coming from reality. So just for you to understand what you mean, this building that we are in, Anatolie Țurcan, Judge Turcan was the president of the procurement group of purchasing this building. And there was someone commenting online who wrote that Țurcanu received a lot of money from the owner who sold this building. So I wanted to ask the prosecutor's office, general prosecutor's office, to investigate who writes such stupid things. But they told me, calm down. You should realize that those who write these things, they are informed by the fact that you were the president of the procurement commission, that you had a separate opinion, that they were intuitively knew. Let those who speak badly about me hear it, that they were wanted to buy actually the building across from prison, which is a restaurant today. I wrote a separate opinion on that. For that separate opinion, they could have really hit me on it, and maybe in the future they will. We were a commission, a panel of 9 members. We've organized the tender exercises, but I wish you good luck, and you should indeed be protected, and good luck in the future. So yes, this is the declaration.
Pardon me. Judge, thank you again for your submissions and answers to the Commission's questions. After the hearing, the Commission will approve an evaluation report stating its conclusion whether the subject meets the criteria for ethical and financial integrity under Law Number 65. The Commission will strive to complete its evaluation report and announce its conclusion as soon as possible. It generally seeks to do so within about a month after a candidate's public hearing. This hearing is now closed. Thank you and good afternoon to everyone.